Welcome to TFE Talks, Navigating Wealth, Business, and Legacy, the podcast from Thomas, Fisher, and Edwards. Each episode, our attorneys bring you expert insight on estate planning, business strategy, and legacy building, breaking down complex topics into clear, actionable advice. Whether you're solidifying a strategy we've discussed or preparing for what's next, this podcast is your resource for thoughtful, practical planning. You ready? Let's dive in.
Hello and welcome to another edition of TFE Talks. I'm your host, Jordan Goewey, and I'm joined today by David Thompson, my fellow attorney here at Thomas, Fisher, and Edwards in Greenville, South Carolina. David, nice to have you. David,
Thanks. Glad to be here.
Yeah, and so we have mentioned before, David, that you're originally from Texas and you're also licensed to practice in Texas, in addition to South Carolina, North Carolina, and Tennessee, where I'm also licensed. And I think a special thing about Texas is that it's a community property state. So you've been very helpful to us here at the firm in helping us understand community property laws and how they can affect estate planning and other planning for our clients as they move in from community property states. And so you're the perfect person to have on the podcast today to talk about the topic of community property. And so thanks for joining me, and I look forward to going over this with you. But let's start with the basics. What is community property and what makes its law different than a state like South Carolina and the laws that we're used to here in South Carolina?
So broadly speaking, in the United States, we have kind of two, what I would call property regimes. We have separate property, which is in the majority of states. I think 41 are traditionally separate property states. And then there are 9 traditional community property states. The community property states have kind of this different law and property regime because primarily they were maybe French or Spanish founded, and they would have more of a civil law background as compared to some of the other states, which may be more founded on English common law. So that's really where the distinction comes from. And we'll get into which states are which in a minute, but the distinctions kind of go back and hark back to, the founding process and the laws that govern these states or the regions that the states are now in very early on.
Yeah, and so just briefly, what are those states that have community property, just so that our listeners have an idea of the types of states that we're looking at?
So there are 9 traditional community property states, and there are 5 what I would call opt-in states. The 9 traditional states are Arizona, California, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. Okay. Those are the traditional states that have had this as their law for at least some period of time and have, and like just generally the default nature of your property in those states will be some form of community property. The 5, what I would call opt-in states are Alaska, Florida, Kentucky, South Dakota, and Tennessee. And the opt-in states are kind of a new blend in a certain way where because of some of the advantages of community property that individuals can get, or I should say married couples can get, there are some states that have pushed forward kind of elect-in, opt-in methods, maybe even potentially using a trust, or maybe you don't have to use a trust depending on the exact state. But the idea being that they would allow their residents to take advantage of some of these benefits.
Yeah, and so you kind of touched on it there, but when we're really thinking about community property, we're thinking about in the marital context, correct? We're talking about married couples and the way in which they own property.
Yep, that's exactly right. Yeah.
And so why is this topic relevant even for a firm like ours where we're in a separate property state? We don't have any sort of opt-in or anything here in South Carolina for community property, but when we're doing estate planning, why is it important that we're thinking through community property issues with our clients?
Well, I think if you're in any state, even not South Carolina, but specifically South Carolina, the main reason is just people are much more mobile than they used to be. There's a lot more migration between states from time to time. And especially in a region like the Southeast, where South Carolina and some of the other states that we practice are in North Carolina, that region is so heavily net migration. There are tons of people moving from these community property states, whether they be California and Texas, which are very large, or even other ones that I listed earlier. And, it's very important to understand some of the benefits, but also some of the limitations of community property when planning for clients and understanding how, if they lived in Texas for 40 years, I mean, it's likely, maybe not for 100%, but it's likely that most of a married couple's property at that point is some form of community property, and understanding, the impact that has and some of the benefits, but also, what that may mean for a gifting transaction or something like that is very important for even a South Carolina practitioner.
Yeah, and so I think one area where community property offers a huge benefit is from an income tax planning situation. And so can you talk a little bit about the benefits of community property in that context and why it's important?
Yeah. And I think the easiest way to describe this is kind of with an example with a South Carolina couple. So in a traditional estate planning engagement here in South Carolina, let's say we had clients that came in and they had a portfolio of marketable securities that they've held for most of their life and is somewhat appreciated, maybe highly appreciated. Our traditional kind of trust planning and structure would be that we would take, if it was a joint account and they were a first marriage, we would take half of the account, if they had 100 Apple shares, we put 50 Apple shares in, the first spouse's revocable trust, and we put the other half of the assets in the second spouse's revocable trust. And the idea there is, we're not trying to make them different, but we're trying to kind of balance their estates and have assets to fund back depending on what the plan is for each of the spouses. Now, the downside in South Carolina, and this would be the same whether it was held in a joint account or in these trusts, is that generally when you're looking at these kind of assets, you're looking at, when the first spouse dies, there's a basis adjustment, and I'll talk about what that is in a second, over just the first spouse's things, right? The second spouse doesn't get that basis adjustment. Typically, and what basis adjustment means, right, is we're taking, if you bought the Apple stock in that example at $10 and you held it for 40 years and it was now worth $100, at death, your basis would be adjusted to the fair market value of that asset, which means that your people that receive it, your successors and interests, they can sell that asset for, maybe little to no gain. Right. So it's a big benefit, and one of the reasons why people a lot of times will hold property through their death if they've had it for a very long time. So South Carolina, and other separate property states are that's kind of the standard regime, and how that works is, when the first spouse dies, we get a basis adjustment over their things, but not the other spouse. That is different in the context of community property. There is a kind of a benefit provided for in the Internal Revenue Code that allows for what I would call a full basis adjustment. Some people call it the double basis adjustment, but I think of it more of as a full basis adjustment, where if one spouse passes away, the community property assets get a full basis adjustment. So in that example, if this was a Texas client and they had $5 million, well, on the first spouse's death, it's possible that they could get a full basis adjustment over all those things. And that second spouse, the surviving spouse, could reallocate, sell with very minimal income tax consequences at that point.
And so it's really a huge benefit, because you're talking about in a community property state, no matter how the spouses own assets, as long as those assets are community property assets, when one of them dies, effectively all those community property assets are going to get a full basis adjustment. And then the surviving spouse can diversify their portfolio, sell off assets, buy other assets without recognizing any gain. So it's really a great opportunity to kind of level set after the death of one of the spouses. And so that's
just to add one
sure.
concept while we kind of touch on what you said there. I think it is important to note that unlike in separate property states, where a lot of times the rights are driven by the titling of the assets, in community property, that's not necessarily the case. So for example, if, and I'm choosing Texas as an example because it's one I'm most familiar with, if a spouse one works the entire time and the other spouse doesn't, and have a lot of assets titled in just their name, well, there is still, if they've been married for 50 years and all that was generated during the marriage, it's very likely that even if it's all in spouse one's name, that property is community property from a perspective of Texas law, right? So now, again, there are caveats and exceptions to inherited property in certain other instances, and then the other thing I will mention is that each state that is a community property state kind of has their own tweaks to what they view as community. So there are differences across the state. So I don't want you to think that Texas is the same as California, but generally speaking, there are kind of similarities in the ownership scheme. So, but I think it's very important to understand that titling is not necessarily determinative of whether the property is community.
Yeah, that's a really good distinction. If I'm in a community property state and I have just an account only in my name, but that I earned during the marriage, and I die, then my spouse is still going to, get or if my spouse died even, then I would still get a full basis step up in that account, because if it had been in my name, then I would have either way. But even if my spouse dies in that scenario, I'm going to get a full basis step up. I'm going to be able to diversify that account. So again, a massive benefit. So it's something that we look for in our practice when we have clients move in from Texas or move in from California. And we have a lot of those clients moving in from other states, with as popular as South Carolina has been in recent years. And so is that a benefit that is just completely lost when a married couple moves from a community property state to South Carolina or another separate property state?
To be frank, there's not a lot specifically in South Carolina on what the effect of someone coming in with community property is. Now, there are some things in our statute that contemplate the continued ownership of community property. And I believe that, given kind of the totality of it, that it is at least contemplated that just the mere moving to a new state does not terminate existing rights that a spouse or some party has in the community property. But I'll be frank, it's a little unclear. Now, in the context of South Carolina, I think what we really want to advise clients in other states that are separate is, one is just to identify and, to the extent possible, segregate existing community property. I mean, I think that's the best that can be done in most instances, is know what is community and make sure that we segregate it. Now, if you have a client that is retiring to South Carolina somewhere and they're not intending to earn additional income, right? Well, that gets easier, right? Because if they earn most of their wealth in a state in Texas or some other state that was community property, well, it's likely that most of their wealth is community and probably will stay community if you just can identify and segregate it. Where it gets a little harder is if they've worked in California, they move to South Carolina, and they're continuing to earn income in a separate property regime, and more careful tracking needs to be done to make sure that we're not commingling assets. I would be careful of acquiring real property in the state of South Carolina with community property assets. So like a couple sells their house in California, comes to South Carolina and buys a joint tenants with survivorship house. Now, again, I think that instance, you could trace those funds fairly easily and show evidence and document that it is community, but we'd much rather segregate that. And one of the plan techniques that we consistently do would be a joint trust or a community property trust to kind of hold and keep those assets segregated.
Yeah, and that was going to be my next question, because you mentioned segregating. I suppose one way that you could do that is by, you come into South Carolina and you've got community property assets and a marketable securities account from another state. If you just set that account aside and you never contribute to it again, maybe you've got an argument that it keeps the rights. But is there a way, and you've already mentioned that there through the use of a trust, that we can provide even further protection to give us a little more clarity to know these are my community property assets? And could you elaborate a little more on how exactly that's done?
Yeah, so it's very common in community property states that like a base form of estate planning would be some form of wills. Each would have a will, and then there would be one kind of joint trust that is designed to be a community property trust. And a lot of times the way the community property trust works is it basically says is spouse one's share of the separate property, or I should say spouse one's separate property, and their share of the community property does whatever spouse one says under the document, and spouse two's does whatever it says in the document. So it really kind of creates two different trusts ultimately at the first death, but it's kind of a place where community property can just kind of be held jointly within a trust structure by the spouses to kind of preserve that character. A lot of times for clients, when they're coming into a separate property state, whether that be, any of the states that we practice in, other than Texas from time to time, we're going to advise them to keep their existing joint trust and potentially amend and restate it so that it clearly says, hey, we've moved to South Carolina, but all this stuff that's in this joint trust that we've taken the time to fund is community property and is clearly identified as community property. And in certain instances where we've had clients that are continue to work, we've gone a step further and, we've really identified those assets on an exhibit or some other means so that we can make sure that we say, hey, this is stuff was community, has been community, and we're not intending to change that just by our move to South Carolina. And I think that's important for clients too, is that, maybe they've moved from that state and they bought that lake house or they bought that beach house in South Carolina. And it may not be too late, even if it's been a few months, right? 6 months, maybe even a year, right? I'm not saying there's a hard deadline on it, but as soon as we can identify that it was community, we should try to put it in a community property trust so we can ensure that it's treated that way.
Yeah, and to your point, there's no hard deadline necessarily, but at the same time, if there is anyone who happens to be listening to this podcast and they are in the process of moving to South Carolina, or maybe you're a financial advisor and you have clients that are moving here from a community property state, it is, I think, important to, as soon as possible, meet with attorneys like us and think about these issues, because we have more options available and more clarity that we can provide for a situation if we're able to address it quickly. And so, David, just to shift gears just a little bit here at the very end, we've talked about community property for folks who live in those states already, and there's a great benefit there when it comes to that income tax basis planning that we can do with community property. There may be a client in South Carolina or another separate property state that's listening to this podcast and says, "Wow, I really wish I could take advantage of those, but I don't really want to move to Texas or move to California." Is there any way that someone in a separate property state can take advantage of community property laws without actually moving to one of those states?
Yes. There are, and brings me back to what I was calling earlier, these opt-in states. And the one I want to focus on here is Tennessee for our region. Jordan and I are both licensed in Tennessee. And what Tennessee has is a form of an elective community property regime that is in the form of a joint trust. And even non-Tennessee residents, subject to certain exceptions and, with certain rules attached to it, can create a Tennessee joint trust and contribute property and transmute that property from separate into community property to hopefully obtain some of the benefits. Now, we talked a lot about the tax benefits and the planning advantages. There are also real structural costs to transmuting into community property, right? Now, for some clients, that's okay, but maybe in other situations it's not. For example, if you've solely held all these assets, if one spouse has solely held most of the wealth, and they transmute the assets into community property, they're creating a different form of marital right than otherwise existed. And, at divorce and at death, that other spouse has different rights and sometimes greater rights than they may have had in a separate property regime. So it's not something that can be entered into lightly, but in the right situation, maybe a long-standing marriage with children of the same marriage, it may be worth considering. And you could establish a joint trust, a community property trust in Tennessee to potentially pursue some of these tax benefits and basis adjustment. I will mention that one of the key requirements of doing it in Tennessee is that you're going to need a Tennessee trustee, right? You have to physically situs the assets to some extent with a custodian, a trustee there. So that can be an individual, actually. And in certain instances, we've had relatives that have served for people looking to pursue this transaction. But if you don't know someone or have a close enough friend in Tennessee or family member, then you may have to consider an institution. I will mention that Tennessee has a lot of trustees that will serve in a directed trustee capacity, which can be a more minimal or limited role than many would otherwise think.
Yeah, absolutely. And so, David, we always like to give practical advice here on the podcast. So for someone who's thinking about moving to South Carolina or moving from a community property state to a separate property state, or for any other advisors, accountants, financial advisors who may be listening to this podcast and they're thinking about their clients who may be mobile, what is the key takeaway and the practical advice that you would give them when it comes to this topic?
I think the key practical insight is I think awareness is one of the things that a lot of people just generally lack, right? And again, most people, when they're moving or changing states, their first thought isn't, let's call our estate planning attorney. And I get that, right? That's a reasonable position to be in. But for high net worth clients or clients with highly appreciated assets, it can be actually very, very important for them in a way that they may not otherwise realize until they get down the road and they've lived there 4 or 5 years and they've never considered getting their plan redone. And they're like, well, we've lived here now, we need to do this. So I think awareness is really what I would drive. And then I would say it can really be a form of benefit. And I'll give just a general example. We've had clients that they moved here and the nature of their holdings are out of state and a community property state. And we've been able to utilize their plan in a way that with an existing, maybe they didn't have a community property trust structure, But understanding the ins and out of community property, even if maybe one spouse holds all the assets, that allows planning even post-mortem in certain instances that could have been lost, but for an advisor in a separate property state said, hey, wait, maybe this is community. We need to look into this more before we give something up here that we otherwise could have got. So I think awareness and just making sure clients are adequately advised on the nature and the property relationship that they already have.
Well, David, you certainly know the ins and outs of this topic, and I've always appreciated being able to consult with you on community property issues when they've come up in my practice. And hopefully our listeners will be able to do so in the future as well. I think you know this as well as anyone. So thanks for joining me today on TFE Talks and for enlightening us with these issues.
Thanks.
Thanks for listening to TFE Talks. For more information, please visit our website at www.tfelawfirm.com. You can also follow us on LinkedIn, Facebook, and Instagram by clicking the links below in the show notes. If you have any questions about topics discussed in the episode, or you have recommendations for future topics, please email us at info@tfelawfirm.com. See you next time.